This could be huge. We don't know yet what the judge is going to do. We don't even know. So the last thing that defense is saying, they're hinting at, there are some really big remedies, and I'm going to talk about what those are in a second. But we need to talk to our client to see if he wants us to make that argument. And so what those remedies could be are the defense asking for a mistrial. Judge, because we argue that the state has violated the law, under the U.S. Constitution, they've referenced Brady versus Maryland as a U.S. Supreme Court case that says the prosecution must turn over all exculpatory evidence. And then they've referenced the Michael Morton Act, which is Texas law, that basically says the same thing, what the state has to turn over when. And so if the judge finds that they did violate that by not turning over this information, then that could render the trial, basically unfair, and therefore grant a mistrial, and that would end this trial, and would start over from scratch. So this is a huge moment. It's really big, and
is this sloppy on the prosecution's part?
Yes, but
okay.
Typical lawyer answer. This is not uncommon. So I deal with a lot of different DA's offices from, I'm focused here in Dallas, so all over the kind of the Dallas North Texas Metroplex area, and all of those different DA's offices have varying different degrees of how open their file policy is. The safest thing to do, in my opinion, for the prosecution is also what the defense wants, which is a complete open file policy. Meaning, not only do we get all the evidence, all the police reports and the original witness statements and all that, but if you meet with a witness, if you call a witness, if you interview a witness, if you prepare one of your witnesses for trial, we want notes on what was said. And the reason for that is, if they've been saying the light was green, the light was green, and then they tell you the light was red, that's a change. And that change may be important. And if that change is very important to the case, then it could be so important that you want to turn it over. I say it's the safest thing to do to have a completely open file policy, because right now the prosecution is forced on their back foot to say, what do we remember her telling us?
Right. This is not a good look. The prosecution doesn't want to be on the stand, and they don't want their investigators on the stand like this. This is not.
No lawyer wants to be put under oath and testify in their own trial. It's not a good look. I guarantee the judge is not happy right now with them, because this is in putting the entire trial in jeopardy, which is frankly a waste of the taxpayers' money and everything else.
Well, let's stop for a second, because one of our commenters is saying, hey, that they were stepped away for a little bit, and they want to make sure.
Yeah.
So
let's reset.
In case you stepped away for a little bit, we had a teacher from the school was on the stand, and she was testifying about what she saw and heard that day, and she described that she had saw dust kicked up, and she described seeing a man in black with a rifle
with long
walking
hair
on the south side.
Yep.
Well, unfortunately, that testimony, that description, she did not give that description to the ranger originally when she spoke to the law enforcement 4 days afterward. She met with the investigators, she met with the prosecutor's office back in December, and they re-interviewed her, which is not unusual because they'll prepare a witness for trial. And in that interview, she described having this man, seeing this man in black, but they're saying she never mentioned he was on the south side.
That's right.
And they're saying, well, we opened our files to you and you didn't come over and get it. Essentially, I mean, I've summed that up pretty well.
Yeah. And earlier we talked about when the state was making, when the defense was grilling into this poor teacher, we said, oh boy, this is risky. She's been very, very likable, very compelling testimony. You don't want to be seen as beating up on her. And I said, it better be a big issue. Well, this is why. Because we don't have access to every piece of evidence the way they do. They knew their case backwards and forwards, and they knew that's not what she said. Not only is that not what she said, but it's really different. Why is it different? Well, because the South Side is the side that Gonzalez is on. And
they're saying he doesn't have line of sight.
He never had a line of sight. And they said that in their opening statement. From a defense lawyer standpoint, you say, look, I would never have made that argument in front of a jury had I had any evidence from the state, which they're required to give me, that gave me any indication that that may not be true. Now the state has basically laid a trap for me that I stepped into, and I look disingenuous in front of the jury, when the reality is I was arguing based on the evidence they gave me. So they whether they meant to or not, they set a trap, and now my client's not going to get a fair trial.
Do you think they intended to set a trap? It doesn't feel like it.
No,
it feels
I
like
don't think
it's
so.
just the prosecutor, and I don't know her name. Maybe the folks out in the comments have caught her name. But the female prosecutor said, "Well, I opened my file, and you said you can come on over." What do you say to that?
Yeah, that is not the way the law works. So the prosecution has the affirmative duty to tender to the defense any exculpatory evidence. It's not come over and view it when you want.
They have the duty.
They have the duty, especially if I can view your file, how can I view your memory of what that witness said in a prep session? That's not in your file. That's not a witness statement. This is why really good prosecutors I've worked with, I had a case in Denton where I was shocked. It was the first time I'd ever had a prosecutor who literally every prep session he did, he turned over his written notes of literally handwritten of while he's talking to the witness. And there's no argument that he gave me everything. And that's why when I said, the safest thing to do is just turn over your file, the prosecution should take notes and they should turn over those notes. And oftentimes I think prosecutors say, well, it's work product, this is our inner strategy. The reality is, unless it really is notes on your strategy, they should probably be turning it over, not just for fairness to the defense, but to protect themselves, because ultimately it's better for them, it's better for the system, it's better for a fair trial.
I know one thing, the judge does not look happy.
He does not look happy because he knows.
Would y'all approach the bench real quick? I'm going to do
Okay, they just killed the mics again in the courtroom.
Which is not surprising because they're having an off-the-record conversation. So it's not surprising. It's the jury doesn't get to hear this. We don't get to hear this. It's going to be interesting because the defense has just had a conversation with their client to say, do you want us to argue? Do you want us to argue?
Do you want to call for a
mistrial?
mistrial?
Right, because look. It is probably a long shot. I don't think it's a Hail Mary. I really don't. I think there's a real chance the judge grants this because it is a big violation if he thinks it is a violation. But from a defense strategy standpoint, the jury hasn't got to see any of this. So all the jury would get to see is they get brought back in. This defense stands up and says, we move for a mistrial. If the judge denies it, it almost appears like the defense is
beating up on the
straws,
teacher,
beating up on the teacher, making ridiculous arguments.
And they're not lawyers, so they don't understand.
They don't know.
I think for folks out here, let's talk a little bit about the genesis. We've talked about Michael Morton. We've talked about Brady. Why does Michael Morton exist? This is a really important law. How did this come into existence?
Yeah, I mean, the way to start with that is who is Michael Morton? Well, he was a wrongfully convicted and eventually exonerated person in Texas. And the genesis of that was that if you turn over all the evidence, we don't get wrongful convictions. And so in the old days, we very frequently would have trial by ambush where the state would turn over almost no information. My very first murder case that I ever handled was in like 2006 or 7-ish, and murder case, and I was given about 20 pages, and that was it. So that's the way things were back then. It very, very much was trial by ambush. Almost no information was given, and thank God the Texas legislature decided that was unfair, both to defendants, but also just to the concept of justice. And so now that's Brady, that's Michael Morton, is you have to turn over everything.